Here at Scott Legal, we know how to navigate the many complex immigration laws to help you live and work in the United States. Turn to us for all your immigration needs. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars or get a free immigration guide by clicking the link below. A common issue that exists in immigration-related cases is how being in unlawful status in the United States can affect a non-citizen of the United States. First, we must understand what unlawful status is and when it occurs. Unlawful status is the time a non-citizen of the United States is present in the United States without permission or legal immigration status. Unlawful status occurs when the non-citizen either enters the United States without legal permission or status, such as when a non-citizen enters the United States without being inspected or paroled by an immigration officer at a border control checkpoint, or when a non-citizen who entered the United States with status either remains in the United States beyond the period of authorized stay granted by an immigration officer at a border control checkpoint, or when a non-citizen commits an act that violates the terms of her immigration status. So, what happens when a non-citizen falls into unlawful status? The non-citizen is barred from applying for a green card within the United States through the adjustment of status process. The non-citizen is exposed to being deported from the United States. Finally, the non-citizen in certain situations may begin to accrue what is known as unlawful presence in the United States. We will discuss the effects of unlawful presence a little later in this video. Are there any exceptions to being disqualified from obtaining a green card through the adjustment of status process when falling out of status? Yes, the bar to adjustment of status will not apply to the following non-citizens. Green card beneficiaries who were inspected and admitted into the United States who are being petitioned by an immediate relative. Applicants based on the Violence Against Women Act. Certain special immigrants such as certain physicians and their accompanying spouse and children, certain international organization employees and family members, minors considered to be special juvenile immigrants or certain members of the U.S. Armed Forces and their spouses and children. Certain employment-based applicants who are subject to a 180-day tolling exception. Any green card beneficiary who has had a green card-related petition filed before the sunset dates of January 14, 1998 or April 30, 2001. Non-citizens who timely filed an application to extend or change status that has been approved. If you are in a situation where you are not considered a special immigrant, an applicant under VAWA and has fallen out of status, you can view our video discussing the adjustment of status process, for a further discussion of the requirements to qualify for a green card through the adjustment of status process by clicking the link below. So, what is unlawful presence and how can it affect a non-citizen of the United States? Unlawful presence is the result of falling into unlawful status which may disqualify a non-citizen from being able to obtain future temporary or permanent legal status in the United States. However, the accrual of unlawful presence does not necessarily start when a non-citizen falls into unlawful status. Committing an immigration law violation may cause a non-citizen to fall into unlawful status, but unlawful presence does not begin until there is a formal finding of the immigration law violation by an immigration officer or an immigration judge. Note that violating status, by staying beyond the period of lawful status granted by an immigration officer does start the accrual of unlawful presence. Also, having entered the United States without status, starts accrual of unlawful presence immediately upon the arrival of the non-citizen into the United States. A non-citizen may be disqualified from obtaining another future immigration status if the specified amount of unlawful presence time of either 6 months or more, or 1 year, accrues in the United States. However, it is important to note that the bar is not applied until the subsequent departure from the United States occurs. Upon departure, the non-citizen may be subject to one of two unlawful presence bars. As a result, there are two bars to account for when reviewing a case of unlawful presence. The 3-year unlawful presence bar, where a non-citizen is barred from obtaining immigration status for 3 years if the non-citizen accrued 6 months but less than 1 year of unlawful presence in the United States and subsequently departs the United States. The 10-year unlawful presence bar, where a non-citizen is barred from obtaining immigration status for 10 years if the non-citizen accrued 1 year or more of unlawful presence in the United States and subsequently departs the United States. Are these then absolute bars? No, as stated they can run for the previously stated 3 or 10-year period, and after the period has run, the non-citizen is no longer disqualified from obtaining another immigration status. Furthermore, the non-citizen under certain circumstances can apply for a waiver to ask that the bar period be waived to allow the non-citizen to apply for the immigration status. Note that a non-citizen applying for a temporary immigration status can request a consular officer to waive the unlawful presence bar. Finally, a non-citizen applying for legal permanent resident status can request the Immigration Service to waive the bar if the non-citizen has a qualifying relative such as a legal permanent resident or U.S. citizen spouse or parent and can demonstrate extreme hardship that will result on the family member if the non-citizen is not allowed to become a legal permanent resident. You can view our video providing a further explanation of the waiver of the 3 or 10-year bar for beneficiary green card applicants by clicking the link below. Does unlawful presence create any other bar? Yes, there is one more bar to be aware of known as the permanent bar. Similar to the 10-year bar, this bar occurs when a non-citizen has been unlawfully present in the United States for 1 year or more, but it triggers after the departure from the United States and then subsequent attempted entry, or re-entry into the United States without being inspected by an immigration officer. The result of this bar is an absolute bar for life where the non-citizen at a minimum would have to wait at least 10 years before applying for a waiver of the remaining lifetime bar. Fortunately, applicants for temporary visas can still apply for the regular waiver with the consulate at any time during the bar. Is there a way for a non-citizen who has fallen out of status to avoid accruing unlawful presence? There are a few limited exceptions. Anytime a non-citizen has lived in unlawful presence before the age of 18 is not counted towards the unlawful presence time. Note this is not the case for the permanent bar where all time in unlawful presence including unlawful presence under the age of 18, is counted in determination of whether the bar applies. As stated, having a timely application for change of status or extension of status approved will avoid unlawful status, and also accrual of unlawful presence. The time after applying for asylum will avoid accrual of unlawful presence. Certain battered women and children if they can demonstrate a substantial connection between the violence and the unlawful presence. Victims of severe forms of trafficking and persons who can demonstrate that the trafficking was at least one central reason for the unlawful presence. Applying for and being granted a temporary status such as temporary protected status, or deferred action for childhood arrivals, before the accrual of unlawful status. Finally, having been granted voluntary departure in removal proceedings, where the voluntary departure order stops accrual from the date of the judge granting voluntary departure up until the ordered departure date. As you can see, immigration laws make it where it's not always clear whether a non-US citizen is subject to deportation or will be disqualified from obtaining an immigration status, so that is why we are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you. You can also schedule your consultation by clicking on the link below, where you can choose a day and time that is most convenient for you.